Welcome back, everybody, to the Auto Accident Attorneys Podcast. Today, I have the pleasure of having Brian Craig of Wood Craig Miller and Rob Hammers of the Hammers Law Firm with us today. These are both prestigious Atlanta firms that have helped co-counsel a lot of our clients in the past and will continue to do so. Rob, Brian, thank you so much for coming today.
Thank you for having us.
I'm excited to talk to you today.
I'm so excited to hear that. The topic now that tort reform is all but passed is to recap what tort reform was purported to be, what it will actually be, or what you pontificate that it will be and how it's going to affect the average Georgia consumer, because it was sold to us as a consumer protection legislation. So I'd like to put on record what we should be able to anticipate in the next year, 2 years, 5 years.
I think if it actually benefited the consumer, then that's a good thing for Georgia drivers in theory. But obviously, we got to see how this all plays out. But my best guess is that consumers are not going to benefit, and it's just going to make claims all that much harder and have some significant limitations to them now.
So you mentioned it's all but passed, and I want to say that it's March 7th, right? And we're about one day after what we call crossover at the Capitol, which means if you didn't have a bill pass out of the Senate, it can't go to the House, and if you didn't have a bill pass out of the House, it can't go to the Senate, and so your bill's dead. This bill, SB 68, which is the omnibus tort reform bill, passed out of the Senate a few weeks ago and has been in the House. So it doesn't have to go back up now to be made law, but it does have to be voted on. It's currently in what's called a rules committee, meaning they didn't put it into a study committee where there's public hearings and people get to come in and testify and tell you how they think it's going to help or not help, and that you have an equal debate on both sides. It was moved to rules, which is just, is there anything wrong functionally with the bill that needs to be addressed before it goes to the members for a vote. And the Speaker of the House, Speaker Burns, decided that he would put it into a subcommittee in rules so that there could be at least some hearings where the sponsor of the bill, John Kennedy from Macon, who's an insurance defense lawyer who authored the bill, he came in and he presented, and they got to pepper him with questions for several days, a full legislative day. And based on his responses, the speaker said, let's go ahead and appoint from this special subcommittee an opportunity to hear from the other side. So they had insurance people come in, defense lawyers come in, and plaintiffs' lawyers and plaintiffs' clients. And so on the 6th, well, I guess the 5th, 2 days ago, there was a all-day hearing at the House of Representatives subcommittee for this SB 68. And we got to pitch our side one more time. So now where we are is, have we motivated the subcommittee to recommend any amendments to SB 68 before it goes to the House to vote? And if we can get some amendments, we can improve the impact of this bill on the consumers of Georgia. If not, and the bill goes to the floor as is, it will be voted on. And that's our last chance. And so what we want to make sure that your listeners hear and understand is, if this is released and the vote happens, it's going to the governor for signature. If it hasn't been voted on yet, you still have time to call your House of Representatives representative at the Georgia legislature and say, don't do this. It's bad for us. It's bad for Georgians. Let's make them fix this bill and vote no. And so where we are at this current date is what they do is called a whip, which means count the votes. How many Republicans and how many Democrats are going to vote with the bill and against the bill? And if we have enough votes to beat the bill in the House, it won't pass and it won't become law. However, if you do defeat the bill on a whip in the House, it can be brought back for a second vote after it goes back to committee. So it doesn't mean it's dead. We got to get through the legislative session, which is called sine die, the last day, right? And if we get to sine die, nothing has been passed, governor can't sign it. So our last bastion of defense is beating it on what we call a floor fight. If that happens, awesome. There is no tort reform. If we lose,
I just got a politics lesson.
Yeah, I was gonna say Rob is as smart as you are handsome.
Oh, guys.
That means we're both terrible.
Yeah, that's not a good thing. That's not a
That's
compliment.
horrible. Who wants to hear that?
Yo, but let me ask you this, Rob. Is there anything specifically in the bill that says that there will be savings passed on to the consumer?
Absolutely not.
And so, like, how is that not an issue? That was like, how were they able to circumvent that? That's my question.
Money.
Then how does that not get more public? I know that I'm asking you almost a rhetorical question, but why? One, insurance companies are publicly traded companies. Anyone can look up their financials and see what the shareholder earnings are, how the stock prices are all in the green and they continue to rise. It's public knowledge what each of these state representatives have received from the insurance industry in terms of dollars. Why do you think, what's going on? How can an entity like this get away, these lobbyists get away with convincing the majority of Georgia citizens that this is actually consumer protection?
There's always been like that kind of personal injury stigma, I think, and it's been fueled historically by the insurance lobbyists. And personal injury is a bad thing until you need it. And there's a lot of people that are significantly injured that are going to be put in way worse positions because now there's just all these roadblocks that are going to be thrown up that didn't exist before and really shouldn't exist because they're, again, like Rob just said, the benefit, consumer protection isn't even addressed. And so it's like, this is just another, that, the big bad mighty insurance committee is able to push their weight around.
I would say this is not a public interest issue, right? Like the word tort reform isn't even something that your average citizen who hasn't had something awful happen to their family and needed to make a claim ever experienced.
Good point.
Right? And so if we as trial lawyers who are trying to build public opposition to this issue are speaking into a universe in which there's Elon Musk bought Twitter and named it X and is basically live streaming his thoughts all day. And you have Donald Trump that's, on TV talking about national issues that everyone is all in a tither about. Get an ordinary Georgia to think about whether or not the price of their auto insurance or business owners, their cost of their commercial liability insurance. Ordinary people just don't care, right?
And how did that end up as like the main agenda on our governor's hit list? I mean, that because I'm with you. I don't think that that's something that I put that on the priority list about as high as the Gulf of America.
Right. I think to your point, that's the crux of it, right? Because this isn't a public issue, it's not going to draw the needle of a political backlash. Governor Kemp has one more full year in office before his political career is effectively over if he doesn't do something national, right? He's been very popular in this state, and his decision on how to handle COVID bought him a lot of political capital, and him backing up his state representatives and his state appointees during the 2020 election when Trump lost Georgia and lost the election bought him no love from the president. And so Kemp is in a spot where he's not going to get any love from the Trump administration when his career's over. And he's in a spot in which there's nowhere else for him to do in Georgia politics. So what's he going to do? Is he going to go fishing or is he going to do something else? He does have a lot of political popularity, but he needs a lot of money. And if there's a lot of money to be had, insurance is where you're going to go. And the Chamber of Commerce, which is on the national and local level that has the interests of business, medical, hospitals, big business, logging, trucking, pharmaceuticals, you name it. It's not just insurance. These people don't want us to pop them when they behave badly. And the best way that people who want to speak truth to power have still in our society is to swell people sit in a box and say, you did wrong and you got to pay what it cost. And that's what keeps people honest. It's why we have seatbelts. It's why we have airbags. It's why we have crash avoidance technology. It's why we have rear collision controls. Every advance in technology we have in safety comes from trial lawyers and not from magnanimous corporations. And people don't know that unless they get on the wrong end of a negligent act. And so what we have here is Governor Kemp's been great to trial lawyers for 7.5 years. But we're useless to them on a national stage. And so now he wants to do something, and he doesn't have the president. So what's he going to do? He's going to go to who's going to pay for his campaign. And he's looking at Senator Ossoff, and he's looking at the United States Senate. And he says, how am I going to get there? He's going to get there through the money he can raise. And they said that money's unlimited if you stop people in Georgia from kicking our ass in court. And so he did it. And that's where we're at.
That is such an intelligent take, and it makes so much sense. But what I'm wondering is it a moment in time where this industry was ripe for it? Or is it, so to speak, low-hanging fruit because of who trial lawyers are? Do we shoot ourselves in the foot with attorney advertising, for example, which I always considered access to justice? What you were talking about, that only trial lawyers can hold these corporations accountable. It's the only portion of law where every citizen has access to justice. They don't have to write a retainer check to get a brilliant mind like either of you to go and step into court.
Specifically, Rob.
Here, right. I'm really good at working really hard and making no money. So to answer the question is, if you look at this bill, it doesn't target the race to the bottom jingle folks, right? The people who are trying to advantage themselves on the very highly condensed population of Metro Atlanta, where there's more auto accidents because of the nature of the population and the configuration of our roadways. This bill doesn't target those cases. It's specifically targeted at big verdicts.
Mm-hmm.
They're tired of us kicking their ass. And the crybaby John Kennedy, senator from Macon, who did this bill, can't beat us in court, so he's asking for a legislative get-out-of-jail-free card. But what's going to be sad for him is that even when he gets these rules, if he gets them through, we're still going to kick his ass because our causes are right and our arguments are better, and he can cry all he wants. We're going to win the cases again, and he'll be back looking for tort reform in 5 years because he just isn't very good at his job.
I don't know about you guys, but I don't know many big verdicts that weren't justified. I mean, big verdicts are a product of a significant injury, or, I mean, they're justified. Most likely, if the insurance company is caught flat-footed on that, it's because they didn't do right in the first place. So everybody gives the insurance company an opportunity to do the right thing. It's just the insurance company, they say that they're good neighbors and they're in good hands, but that's just not the reality. So but I've tried a bunch of cases. Rob, I know you've tried a bunch of cases. Have you ever gotten a big verdict from an insignificant case?
No.
Yeah, it doesn't happen.
That's the wildest thing, is the premise of the entire setup when they're bringing out these outlier nuclear verdict cases. They don't actually review the facts or present the facts as how it was. I remember one that I actually came up on the text thread. I'm going to butcher the fact pattern, but it was presented to the committee as if the insurance company had offered $2.5 million and plaintiff said no, and they got $25 million, where it was actually in reverse, right? The plaintiffs were ready to settle at $2.5 million, and insurance company told them to go kick rocks. And they went to court, and they got hit. And I think that if you take that threat of that nuclear verdict away, it takes away any leverage whatsoever to negotiate. Insurance companies don't want to pay to begin with.
Yeah, I mean, using that example specifically, it's like they still didn't do the right thing. It took a jury to say what it was.
Right.
They had an opportunity to sell far less than $25 million. There wouldn't have been a nuclear verdict. There would have been probably a fair settlement. But the jury thought it was worth way more than even the plaintiff's lawyers did.
The way I'm thinking about this right now, Rob, do you think it's correct? Like, what I just said, that tort reform is going to take the ability of plaintiffs, trial lawyers to not get those nuclear verdicts. Is that something that's going to happen?
So just for context, Georgia is a Dixiecrat state. We were Democrats for 100 years, mostly because Abraham Lincoln was a Republican, right? And so even though the politics might have been conservative, our politicians were Democrats. And that changed around 2000, right? And for the first time in over 100 years, the House of Representatives and the governor and the Senate were Republicans in 2005, and they were going to get even. And they passed SB 3, which was the first time we had massive sweeping tort reform in Georgia. And that was the offer of settlement statute. It was caps on damages. It was apportionment of fault. These vehicles that were supposed to constrain verdicts and to improve the lives and fairness of the judicial system. All these little buzzwords they use to say, we're going to save insurance companies money and we're not going to get beat in court anymore for our wrongdoing. It all passed. And the caps was devastating, but they were unconstitutional, so those got kicked. And then since then, the offer of settlement statute and the apportionment has been more of a boon for plaintiffs' lawyers who knew how to use them than the defense bar who asked for them. It's probably going to be the exact same outcome here. They've asked for a whole bunch of stuff that they think will help them win cases, but what they can't change is you did wrong, we proved it, and then you lied about it, and you tried to hide the evidence to prevent us from getting a fair result for our client. Then the jury hears it, and what's the jury going to do? They're going to pop you.
Punish, yeah, for sure.
They're going to pop you every time. That ain't going to change, and that's what they hate, but they'll keep on trying to find ways to stack the deck. And the worst part of the stacking the deck from this bill is they've asked for mandatory bifurcation on the motion of any party, which in short, simple terms is if you file a lawsuit, you got to prove somebody's at fault and you got hurt as a result, right? And what they want to do is first you got to prove they're at fault, and then you got to prove that you were hurt. And then if they did something wrong and you want punitive damages, you got to have a third phase of trial. Now, already we have in our system, if it's punitive damages, you got to prove your whole case first. And then if you win, the jury decides whether or not they believe the conduct was egregious enough to go to the punitive phase. So what they want to do is add one more layer. And what's crazy about that is 90% of the cases that get filed are simple negligence automobile accidents where the defendant was cited with a ticket and there's no dispute as to who's at fault. And it means a jury trial on a car wreck can take a day to 2 days, right? And you can dispense justice and a court can manage their docket. Now all you got to say is you got to prove that I was at fault. And now a simple car wreck case will take a judge a whole week to try on something that should take 2 days, and it's a waste of everybody's time. And the only reason they want that is because on big cases, they want to keep it all about the conduct before you hear any evidence about how they're paralyzed or how they're dead or anything that's really, really egregious in the damage.
So in my cases, the auto ones, oftentimes they stipulate the liability.
Mm-hmm.
Do you think that still will happen, or you think that that's something that's going the way of the buffalo?
Well, I think what's going to happen is judges are going to be really, really, really terse with folks who play this system where if you got a rear end collision and you got cited for a ticket and you ask for bifurcation, you don't have a judge that's going to grant anything you want. So I think that
if I'm on a jury, not forget what the judge does, but if I'm on the jury and I got to hear that the plaintiff is having to prove something in which the defendant was cited, and it's clear-cut rear-end collision, and they're fighting me on that. By the time we get to the next phase, I'm killing them.
I think that
That's me.
If you're practical on the defense side, I think nothing changes, right?
Yeah.
But what we've asked it for as a simple fix, this is how reasonable we're being down at the legislature trying to get this bill into somewhere where it's not unreasonable, and that is, let the judge decide. Upon motion of either party, the judge may bifurcate the trial. Not shall, just may. And those words are important. In the statute, if the judge has the discretion and it's a product liability lawsuit and you're saying that the airbags didn't deploy in your car or the roof crushed in your car, let's determine whether or not Ford or GM should have known that problem with the vehicle was a problem that they did something about before this plaintiff got injured, before we talk about their injuries. Okay, the judge might say yes to that, right? But when you put shall do it, it means unscrupulous or opportunistic defense lawyers will use this opportunity to prolong trials, stretch out cases, and prevent trial dates so that they can make trials last longer and it harder for plaintiffs to get justice.
Just make it unduly burdensome.
Mm-hmm.
Let's pretend that happens, that GTLA can't get the word shall to may. What do you think the practical effect on cost of litigation would be?
I think for those big cases, I mean, the complex cases, it goes up exponentially. But the reality is also, I mean, they're fighting that phase anyway. I mean, so I don't know, not to dance around the question, but if Florida was talking about like how they got hit with all this tort reform stuff and how devastating it was going to be. And I don't practice law in Florida, but I haven't seen any personal injury attorneys running out of the state. And I think that it's just, to me, it's going to have to be a wait and see thing because the cases don't change. What we have to do changes, but I think that the example you gave about like the offer of settlement statutes and I mean, we didn't really know how that was going to affect the cases until we saw how it affected the cases. And I think that that's kind of where we're at. I can't really see any defense attorney changing his strategy on a clear-cut liability case.
And to Brian's point, look, I mean, if you're doing motor vehicle accident cases, right, they ain't paying those lawyers that's defending these things the kind of money it takes to work up a really big trial. So they may not even get permission. They might be like, you can have whatever strategy you want, but you get $3,000 to do it. Go do you,
Right.
and that'll curtail the behavior. So to your point, and I think I actually had a conversation with a lawyer down in Florida about tort reform, and he said that exact same thing. He goes, look, it's been 2 years. Everyone was all histrionic about it and wring their hands and gnash their teeth, and nothing's really materially changed from the actual recoveries that we're getting and the justice that we're able to obtain for our clients. So, we take that same philosophy here because we're not going to stop representing injured people. But what I will say is we don't need it. It does no good. It's just more stacking the deck.
It's BS.
Yeah.
That's it. It's BS. And again, I hope that nobody from the insurance company comes get me. But if it was for the intended purpose of consumer protection, lowering your rates, that would be mentioned in the bill somewhere.
Nabila Islam is a senator from Gwinnett, and she actually put an amendment to SB 68 on the floor before it was voted on to go to the House that said, we just need the insurance companies in the statute to be capped. They can only float rates to a inflation-based rate increase. And that amendment was voted out. Who's shot?
Quelle surprise.
Yeah. And the vote was 33 to 26. I mean, so they barely won, and it was partisan.
But that's like the most common sense thing. Like, let's ensure that the intended benefit is actually going to reach the intended target, like
the beneficiary.
Yeah, the beneficiary.
And if you're watching the news, you'll see that the new Speaker of the House in Florida has called to task because it's become apparent that the insurance companies were using their manipulations of their profits and loss statements to hide revenues and information on claims to sell this big verdicts are impacting rates. And then after the fact, they filtered that money through. They've done great, and that nothing's materially changed, and rates aren't really changing. And so now the House is going back and saying, let's reevaluate whether or not this tort reform bill did what it was going to do, and should we make some fixes that fix holes. I've got my law school roommate and best bud. I went to Florida State. He's down.
That's okay.
Hey. I went to Georgia as an undergrad. Let's all be nice here. But he's down in South Florida, and he does personal injury protection. So if you're a chiropractor or a radiologist or whatever, and there's an automobile accident, $10,000 off the top is no fault to pay doctors for care, right? But if the facility submits the bill to the insurance company, the auto insurance company, to pay those bills, and they discount the bill based on the CPT code, and they do so outside of the parameters of their rules, you can sue them for attorney's fees for not paying the full bill.
Wait, this is in Florida?
Yeah, it's called PIP.
Yeah, I know PIP.
Yeah. And so he's been doing PIP litigation for
Is it under the
20
guise of like a non-medical professional making like medical decisions? Is that what it is?
No, it's just simply I'm a radiologist and I charge $1,500 for an MRI. I submit my bill for reimbursement to Geico, and they say this wasn't medically authorized, so we're only going to pay you $300 on it. So that $1,200 delta is at play. They can hire a third-party attorney to sue Geico for not paying their bill.
The radiologist company.
Right.
Okay.
Right. So the client of these lawyers is the facility seeking to be paid from the auto PIP insurance.
But what's the cause of action there? Why?
Breach of contract
I see. Okay.
under the personal injury protection statute.
Okay.
And they
how does
erased
the radiologists have standing to bring suit against Geico?
They have standing under the PIP statute because they're supposed to be paid from the PIP policy, and you breach the contract by not paying the full reimbursable rate.
Okay.
So that's a whole cottage industry.
You want to go 50-50 going to Florida?
Well, the tort reform,
Mexico, bro.
the tort reform bill erased it. It's gone. They got rid of it.
They got great PI laws there. Okay.
So they got rid of PIP in this Florida statute, and looking at it 2 years later, the Florida legislature is like, we still have this huge problem in processing claims and paying, but you've pulled this mechanism for accountability out. Let's reevaluate it and let's reinstate it. And so now it's back up for debate. And that's a lobby thing too, because all the PIP lawyers are like, we want our jobs back. But like, that's politics, right? And that's what's going on here is down in Florida, they promised they were going to lower premiums and reduce verdicts. They haven't reduced verdicts and they haven't lowered premiums. And Florida legislators are like, whoa. Did we get what we bargained for? And that's what we think could happen here in Georgia.
You know what I don't want to do?
What's that?
Debate this guy. He's really smart. He's really good. He's really good.
I just got whiskey.
Yeah. Brian, Rob, love you guys. Thank you so much. It was enlightening, and I know my mom's gonna get a lot out of this episode.
And my wife.
Nobody's watching on my side. Oh, actually, I do have one thing. Actually, I do want to say. So my girlfriend comes from a very conservative family, and when I met her, her opinion of personal injury was probably that of many. Now she works as my office manager, and she sees the good that we do. And it has been really cool to see like this opinion kind of go from like, it's done a 180, but she was definitely one of the, like I'm not saying she was an insurance, she's a licensed insurance agent, but she was like programmed to think,
yeah,
this is bad. And I think that that's what the insurance company has done, is they've programmed a lot of people to say, this is a disingenuous business and these are disingenuous injuries. And she has seen that hey, maybe there are some, but there are a lot of people that are, I mean, their lives are upended from this.
Yeah.
And that's what we're trying to do, is we're trying to just, get them the justice that they deserve, because you can't roll back the hands of time, but you can try to get them back to where they were.
Yeah. I mean, I think that's right, Brian, is that it's not a perfect system. There's no way to undo something awful, right? But we're a civil society. And that's why it's a civil justice system. And the only remedy that we have is money. And that's why we pay for insurance. There's no other reason for them to exist. In order for commerce to happen in a society where stuff can go wrong, is for us to buy insurance. The whole point of insurance is to pull risk and to reduce the cost of doing business and being in a condensed, populated, civilized society. And the fact that they actually take our money and they hate us for asking them to give some of it back is reprehensible. But yet,
crazy.
Their job is to increase profits. And so they can't reconcile why they exist with what they have. And that is their problem. But thankfully, we're here to hold them accountable.
I love that.
Yeah, that was good. That was really good. I echo what he just said. I did want to say thank you for having me, but you guys are great lawyers and great friends. So this has been a treat.
Oh, amazing.
Yeah, I'm
Thank
just
you
so
so much.
glad that you invited me, and I'm just hopeful it doesn't pass.
I wasn't invited, but I'm happy to be here.
Love you guys. All right, guys, take care.